Okay, good morning. Welcome to our fourth Tuesday legal marketing update for lawyers. As I said before, this is our May 2016 session. My name is Victoria Blute, and I am the Lawlytics Community Manager. I deal with a lot of the educational efforts here at Lawlytics, as well as keeping my ear to the ground for any web and tech trends so that you guys can stay on the cutting edge of what you do. Joining us today is Dan Jaffe and Larry Bodine. Dan Jaffe is the Lawlytics CEO and also an attorney. As you can see here, he got his JD in 1998 and then was admitted in Washington, Arizona. He spent 10 years in private law practice, built practices in Seattle and Phoenix, and took over 100 jury trials to verdict before turning his attention to legal technology full-time. As well, we have Larry Bodine, who is an attorney and also our senior legal marketing strategist. He was admitted in Wisconsin in 1981. He is the editor and former editor of a number of publications, the former director of marketing at the Sidley Law Firm, and also a popular legal marketing blogger and very active on social media. Let's talk about today's session. So here's what we have for this month's agenda. First, we're going to talk about a recent development in sort of accolade advertising and how that relates to being in control of your law firm on the web. Then we're going to talk about a topic that many of our members have heard about and are curious about, but it's a topic that's often not well understood, and that's the Longtail Search. We'll talk about why thinking about Longtail Search can benefit your law firm's business. Then we're going to discuss the sunk cost fallacy and your law firm's website. When your website isn't bringing in the traffic that it used to, if you've got a tainted domain, when the right choice is to be patient and when the right choice is to potentially start over again. That will bring us to our next topic about making the switch to a different website company. There are some easy ways to make the transition pretty painless and stress-free that don't put your web presence at risk, and we'll talk about those. We're also going to discuss another aspect of developing your web presence, and that is when it's the right choice to consolidate multiple websites or blogs. Lastly, we're going to discuss the benefits of having a built-in blog on your law firm website. So let's look at our first topic. So yesterday, Larry brought something very interesting to our attention, and I'm going to let him tell you about what that is. Larry?
Victoria, thank you very much. And Dan, good morning to you.
Good morning, Larry.
I wanted to bring up an important notice that was just issued by a major state bar association. And it affects anybody who uses, anybody in New Jersey who uses the designation super lawyers, rising lawyers, best lawyer, leading lawyer, and so forth. The State Bar issued a notice saying that, cautioning attorneys that they may not state that they are a super lawyer or that they are the best lawyer. However, it is permissible under the ethics rules in New Jersey to state that a person was included in a list of super lawyers. This is a very big deal. There are 42,000 attorneys in New Jersey. It's a major East Coast bar association. It's the kind of opinion that I see being picked up in other parts of the country. A couple of other things to note about this, and by the way, we do have a blog post which I wrote on the Lawlytics website where you can find a synopsis of the opinion as well as a link to the original notice. So I highly encourage you to tell your colleagues about this. Tell them about this webinar as well. This is the kind of thing that we cover on the fourth Tuesday of every month. The State Bar said that lawyers may not advertise the receipt of all of these awards unless the organization made an individualized inquiry into the professional fitness of the lawyer. These super awards are suspect in 5 situations. One is when the lawyer wins the award through an email or text vote, or second, if the award is a a reward for just joining an organization. Third, it's suspect if a lawyer participates in the conferring organization's website. Fifth, if an attorney can enhance his or her rating or 1 to 10 score simply by endorsing other attorneys and being endorsed in return, this is suspect. And then the fifth thing, Dan, is that if a lawyer responds to the public about legal matters on the organization's website, this makes the ranking completely suspect. Dan, does this kind of a notice surprise you? Were you expecting the state bar to come out and say that these super lawyer designations were suspect?
It didn't necessarily surprise me. What's more surprising to me is that more states have not done a similar thing, and that this isn't more at the forefront of the collective conversation that we're having about how we talk about ourselves as individual lawyers and about the profession. Couple questions for you about it, though, Larry. The way that I read this in the title, it almost seemed like this was a reminder, like they had maybe issued this before, or is this an issue of first impression that they just happened to use the word reminder because under the ethics rules it should be patently obvious?
What happened here, Dan, was the state bar was receiving many grievances and complaints, and it finally spurred them to issue this notice to the bar. The analogy that I make is, it's like hearing about a reminder from the FBI that it's against federal law to conduct money laundering. If I were a money launderer, I would immediately be under notice that the FBI is going to be cracking down on this. And I think the analogy applies here to attorneys.
So, but I mean, everybody that launders money presumably knows that what they're doing is illegal. So, is the bar taking the same kind of stance there, where they're saying, attorneys, you should know better. You should have known better all along, and we're just kind of giving you this additional notice because we're going to start lowering the boom?
Well, we don't know what the state bar is going to do, but they've made it clear now what the rules are and what specifically is unethical. And it's most of the ways that I've seen attorneys use these super designations would be unethical under the State Bar of New Jersey. Again, we have a synopsis of this and a link on our website. Highly recommend that attorneys in every state read this, because if it's not in effect in your state, it's coming soon, and nobody wants to hear from the Disciplinary Committee.
How closely, in your experience, does one state pay to another in terms of warnings or guidance like this? I mean, are they all talking already, or do they just read each other's stuff?
No, they're very much in touch. In fact, there's a national organization of state bars where they meet regularly under the auspices of the American Bar Association and exchange notes. So it's always striking if you have an opinion from a very populous state like California, Illinois, New York, New Jersey, Florida. States that issue these kinds of rulings are observed by many states and taken into consideration. What I see happening is that the American Bar Association will investigate the topic. They could potentially create a model rule, and once that's promulgated, it could be in effect. It could be adopted by all 50 states. So this, to me, tells me which way the wind is blowing and which direction the trend in lawyer ethics is taking.
So now, if you look at websites that are out there, on individual websites, and then on more collective websites, such as the super lawyers and the Avos and so forth of the world, you have a lot of lawyers that are participating in them, and it's almost so ubiquitous with some of these things that it's a question of who isn't participating more than who is.
That's exactly right.
What do you think the likely, assuming that they do start cracking down on this, and assuming that people are members of super lawyers or have been selected and are using that in their advertising, but using it in incorrect ways? Um, does this signal to you that the notice period has started now and attorneys should be aware of it and start making changes if they are in violation or potentially in violation? Or do you think that there may be a stronger admonition before actual disciplinary measures may be taken?
I infer this to be a warning. If I practiced in New Jersey and I had any one of these super or AVO designations on my website, I would immediately delete it. I don't want to have anything out there that's going to attract the disciplinary committee. What I read into this is that the disciplinary committee in New Jersey is looking for a test case. They've now put everybody on notice that using these designations is unethical, and they're not going to announce that what particular law firms are going to pursue or start an enforcement action. But if it were me, I would do everything to make sure that I was not that first test case.
Right. So it's almost like a situation where you don't necessarily have to be the fastest runner when the bear is chasing you. You just have to outrun the slowest runner, and the bear is going to get that runner. Does that make sense?
Yep. That's a perfect analogy. That's exactly what's going to happen.
So then they'll go, assuming that they have the time to pursue this and so forth. They'll go after a test case, make an example of that person. Then there'll be precedent, and everybody else will likely fall in line pretty quickly. If you were to guess, how many of the lawyers that have these kind of accolades, and I know it's singled out like 7 or 8 of them in particular, but did it leave room for others as well? If somebody comes up with different awards, in addition to the super lawyers, the best lawyers, the lead lawyers, stuff like that.
Sure. Well, the state bar spelled out in exactly what is permissible. And let's take the case of lawyer Jane Doe. It would be permissible to state that Jane Doe was selected to the 2016 Super Lawyers list. The Super Lawyers list is issued by Thomson Reuters. A description of the selection methodology can be found at, and then you put in a website address. And it continues, no aspect of this advertisement has been approved by the Supreme Court of New Jersey. So that's permissible. If you vary from that or put up anything that says more or anything that says less, I think you're inviting a disciplinary complaint in New Jersey.
Right. So if you say something like, I was selected to be a part of the list or selected amongst those who made the list or whatever, that's okay. But then saying something like, just on the front, you have a lawyer with a cape or something, and you're saying I'm a super lawyer. That's not okay. Is that your interpretation?
Well, a lawyer with a super cape would be an egregious violation.
Well,
just saying I was selected by super lawyers is insufficient. You have to state that you were selected to be on the super lawyers list, not that you are a super lawyer.
Right.
And then you have to state who promulgated this designation. Super lawyers is promulgated by Thomson Reuters. And then you have to include a link to the methodology, because if the methodology is that you won a contest or that you paid to be on the website, that's not sufficient.
How does that go? How do you? And this is kind of a question that I think maybe nobody can know the answer to right now. But I'm curious what your opinion is on a situation like you've got an AVO, for example, that comes up with kind of a dynamic 1 to 10 scale ranking, and it doesn't seem like they make the exact formula for their algorithm available for examination. Do you see that falling under the umbrella of things that will need to be known to a lawyer before a lawyer can use, let's say, an AVO designation?
Well, in New Jersey, the answer is yes. The anything where the methodology is not explained is suspect. Anything where your 1 to 10 rating on Avvo is built by meaningless things like endorsing other attorneys for advertising purposes, that's suspect. These who knows what the state bar is going to do, but a very influential authority has just said this is what's right and this is what's wrong.
Right.
And we'll be watching you.
Makes sense. And I want to move on in just a moment, but I do just want to, for those who are listening live and for those who may in the future listen to the recorded version of this, just let everybody know that neither Larry nor I are licensed to practice in New Jersey. And this is just based on a reading of something that we discovered last night. Obviously, consult with Ethics Counsel if you have specific questions. We're not trying to officially interpret it nor give legal advice here. But this is a trend that we just see coming, and it's interesting that we have this particular written dispatch from New Jersey now to kind of add to the fuel. Should we move on to the next slide?
Yes, let's get into some additional practical information about searching for different ways to search for attorneys online.
Well, before we do that, Tori, can you go ahead and advance it to the next slide?
Sure.
So the question here, I think is also leads to what happens if you're not in control of your website and you have this kind of messaging on there. And, oftentimes we hear from people who want to have their website changed or want to gain some control over it. And they simply can't do it because they're dependent on a webmaster. They have to email them or they have to call them. And sometimes those people aren't that responsive. And so to me, the natural follow-up from this discussion about, here's something that some attorneys could get caught in the crosshairs of with this New Jersey situation. What happens if your site is not currently in compliance and you need to make the changes and you can't? And so, we put this as just a follow-up here to say that, I find it to be irresponsible, not necessarily to delegate some or all of your marketing, but to do it in a way that you can't change things if and when you want to and need to. And it also kind of begs the question of, well, what happens if somebody else is in complete control, not only of the messaging that's going onto your website, but also in the mechanisms for changing it? Larry, if somebody used that as a defense, like let's say the warning like this went out, and then all of a sudden that slowest runner gets caught by the bear. Let's say it doesn't even take very long, and that person didn't really have a chance to react. What's your opinion about what would happen if should that person have at least kind of a trail of communications they've tried to now comply if they were unable to access it? How do you feel about that, Larry?
I think that the disciplinary committee would not be sympathetic. They would not be impressed by the fact that you weren't in control of your website. They would not accept that as a defense. It's kind of the equivalent of a pilot crashing a plane and saying, I didn't know how to operate the plane. And so that's my defense for crashing the plane.
Right. And I believe it's every single state says that the lawyer is ultimately responsible for all of the marketing messages, at least in medium that they own and do control or should control. Is that accurate?
Yeah, I would say so.
Okay. All right. Anything else that you want to add to this one, Larry?
No, I encourage everybody to read the blog post and read the notice, which is on the Lawlytics website, and you can decide for yourself.
Sounds good. All right, let's move on to the next slide.
Okay, so the next slide has to do with Longtail Search. I had recently written a blog about voice search and how you can make sure that your law firm's website is ready for new developments with voice search. More and more people are using voice search on their mobile devices, and that's important because that we know statistically it's likely that the next person who visits your law firm website is going to do so from their smartphone or from their tablet. And we were already headed in this direction with search engines in general, but the addition of voice search makes it more likely that a potential client will ask very specific questions to search engines rather than typing in keywords like DUI Attorney Florida. And those very specific questions that potential clients are asking brings us to this topic about long tail search. So what is it? How does it affect your business? Dan, I will start with you on this one since I know that you've been talking about this recently with our members.
Thanks, Tori. Yeah, it's something that's really not new. I mean, it's been around for a long time. It's the way that people have searched for a long time. It's not the easiest thing for marketers to talk about. Can you advance to the next slide? Because I think that diagram is going to be a little more detailed. Yeah. So I don't know how well people can see the various stratifications of this curve, but when we talk about the long tail, we talk about in that blue area off to the right where the curve starts going downhill. It tapers off to about where you see it, fading off the screen, but then it really continues on virtually forever at about that level. And so when you're looking at things in the green area, words that people search for, high-level words, one word like attorney or law, or even a couple words together, estate planning attorney, family law, that type of thing. Those things are searched for in aggregate more often than what happens when I'm facing a child custody hearing in New Jersey and have a felony, something like that. But it's those longer searches that people that actually have specific problems that need to engage attorneys are actually searching for that result in as much or more business for attorneys because they're very specific searches in that way. And so the opportunity really is in that blue area of the long tail rather than where everybody is trying to compete and driving the cost of competing up so high that the return on investment is either non-existent or the cost of client acquisition is so high that most lawyers are priced out of competition. It's very easy for any lawyer who puts in the time and the effort to really think about what questions their clients and potential clients have when they're searching the web to actually compete without spending a whole lot of money with lawyers that are spending thousands or even tens of thousands of dollars a month to go after the keywords that rest more at the head of this curve rather than in the tail. And so, and we believe that it's going to become even more important as people go from typing out all their queries into Google and the other search engines to just dictating them, because the only thing that really stood in between people searching using more natural language and that actually appearing as even more of a factor is that people don't necessarily want to type those things out. It's easier just to type, phrases sometimes. But when they're talking, there's no limit to what they can say quickly. And so that's where we've seen things going for a long time. There's a book out called The Long Tail. It's not specifically for attorneys, but it really talks about this in depth. Uses one of the examples that is frequently used is what Amazon.com did for books. Well, they started out just as a bookseller, and up until Amazon came along, the best-selling books, or the books that sold or even survived, were much fewer in number because they were limited by physical space in the bookstores. Even super bookstores like the giant Barnes and Nobles and so forth could only hold so many books, and so they would have to make the decision as to which books were the most likely to sell and stock those, because shelf shelf space was at a premium. Along comes Amazon, and you can have any kind of obscure book stocked and ready to go. And so people are buying a lot more diverse selection of reading material, and it's opened up this whole new market for more niche type books. Same goes with law. And so, I say this over and over again. So for those of you who are regulars, this will not be news, and I'm sorry for the redundancy. But if you think about it from the perspective of a client or potential client sitting across the desk from you in your office, what questions are they asking of you? What concerns do they have? What do they really want to know? They're asking Google the exact same things, and those things are all in the long tail. And those things are all, both fortunately and unfortunately for those who are lazy, those are not things that somebody that doesn't understand both law and the internet can create for you. So no pay-per-click marketer is going to be able to do that in an effective way. No SEO person is going to be able to optimize for all the things that your clients talk about. Only you can really do that effectively by taking control of your web presence.
Dan, just to underscore the importance of what you were just saying, 70% of all online searches are so-called long-tail searches. And to kind of put it into perspective, a long-tail search is a descriptive, specific phrase. It's a complex question such as, how do I protect my rights in a DUI traffic stop in Georgia? That's an example of a long-term search. And if your law firm turns up on a search for that, there's a very high likelihood of converting that visitor into a client. So it's a very important marketing. It's very important in marketing. And as a practical matter, you might ask yourself, well, this is all great. So what do I do now? And the answer is you need to write content. You need to write blog posts, fresh, new material on a regular basis, and post that, on your website, because it's this fresh, new, original content that the search engines that your potential clients are looking for in search engines, and they're speaking these complex questions into their cell phones by using Siri or OK Google. And if you have a good corpus, a good portfolio of of blog posts published, these long-tail searches are going to find you, and the clients are going to have a high likelihood. The visitors are going to have a high likelihood of becoming clients.
That's exactly right, and that's really the main premise behind Lawlytics. In addition to just making marketing yourself online just dead simple for any attorney that wants to do it, is to use it as a communication device to answer clients' questions. And we've seen lawyers that were spending thousands of dollars a month on disposable pay-per-click advertising go ahead and start creating content to answer those questions, and go from spending a bunch of money to making a bunch of money. So by doing it, by investing the time in creating the content, whether you use a Lawlytics system to do it or any other system, you create an appreciating asset, because once you create those pages of content, those pages go to work for you without additional cost or complaint. And so, most lawyers, once they understand this and they start experiencing it, they see the value of it. They end up wanting to do it on a regular basis. And what we've discovered is that those, especially those that have started doing it for themselves, that start seeing the success that it brings, end up getting addicted to it. But then sometimes there's just not enough time in the day. And so if you do engage somebody to write it for you, make sure you engage a company like us that has attorneys that are actually writing the content, editing it, and making sure that it's quality check, not just for search engine optimization, which is certainly important, but it's less important than actually communicating it accurately in the way that the clients, language that clients use, and also in a way that's mindful of the ethics and other advertising provisions that make advertising for law firms so complicated. Had a question that came in, and normally we save all the questions for the end, but this one I want to just reiterate the answer to right away. Lisa asked, what was the name of the book that I had mentioned? The book is The Longtail, and it's by Chris Anderson. It's I think it's at least 10 years old, if not longer, but it's still as relevant today as it was then. It's a good read.
So our next topic, which is related to this a little bit, is the sunk cost fallacy and law firm websites. So for attorneys who have gone through multiple SEO companies and haven't seen the results that they're looking for, or have had their presence damaged as a result, for attorneys who have purchased a previously tainted domain and are suffering as a result, for law firms who have taken a hit in the search engine. Can a once great website be saved, and when is it time to start a new one? So for this topic, Larry, I'm going to start with you.
Well, you know, my heart goes out to my fellow attorneys who discover that they have a website that appears too broken to fix. How does this happen to attorneys? The story that comes up a lot is an attorney will use one search engine optimization or SEO company. They'll mess up the attorney's site, and so the attorney will hire a second one, and then the attorney hires a third one to repair the mistakes of the second one, and on and on and on it goes until the attorney has now spent tens or thousands of dollars on this website and feels very invested in it. You know, they want this website to work. However, for some reason or another, it's not coming up in the search engines. It may have been so badly botched that the search engines have demoted the site. They've said this is a troublesome site, and we're not going to feature it in any of our searches. And so the question arises: what does an attorney do here? And you know, Dan, I got to say, sometimes the website is just too broken to fix, and you know, you could wait until it recovers, but you know, that could take years if it happens at all. And you know, in a situation like that, when an attorney comes to you, Dan, what have you done in some cases? What do you advise these attorneys?
It's, you know, it ends up being an emotional decision for the attorney as much as a logical one, especially when they've been told that these are the things that you need to do. You need to go and build links, for example. But what the person that was telling them about, you know, buying links from them and building links didn't tell them was that it's a temporary measure that's against Google's webmaster guidelines and is likely to result in bad things happening. And when those bad things happen, you know, not only do they feel, I think sometimes frustrated, if not even ashamed of making the choices that they did, but they feel like, well, I invested this money in doing something that was supposed to help this website, so I'm you know, I'm more committed to it. And sometimes it can be saved, but you know, a lot of times what we have to do is say, look, you know, we know if we start over, it's going to be a matter of months before we start seeing this thing start to take hold. But if we don't start over, instead we try to save what has already been done on there, especially if there's been multiple webmasters that have touched it, or if there's a few really bad operators in this space right now. And if we see websites that have been optimized, and I'm using air quotes when I say optimized, but by these few companies, the better choice may be to just start over. That doesn't mean that all is lost, because some of the content from the site can be saved, repurposed for another site. We've actually seen times where we've seen a website that's been failing, and we import it into Lawlytics from another provider, and we make an agreement with the attorney that, hey, okay, we're going to get this imported. We know you like your domain name. We know that you have that domain name listed on your business cards and your letterhead, and all of your clients know it, and you're using it with your email address, that type of thing. So we'll give it a try, but we want to closely monitor it with you. And if it doesn't start coming back within 2 months of correcting the obvious problems that are on there, we need to really have a serious talk about potentially switching to a new domain name. And when that happens, oftentimes we've seen sites take off almost instantly and go from a site that used to be on the front page to having somebody go in and do some shady SEO tricks on it, to getting it demoted to page 20, to going back to page 1 on a new domain within a course of a few short months. One of the things that we want to be really careful of as we're considering that is the new domain name that's going to be used. We had a case a couple months ago where somebody came in with a newly registered domain, and it turns out that that domain was used for spam about a decade ago. And even though that bad use of it was more than 10 years old at the time, that was still a problem with Google, and Google still wasn't ranking it. And just switching the domain name to a new domain name that we knew was never used made a big difference. One of the things that I've written fairly extensively about in the early days of it, which was about a year ago, even a little less than a year ago, is the new top level domain .law. And I started out very skeptical of the .law domains, .attorney, .lawyer, .abogado, those types of things, because they're essentially domains that are created out of thin air. But the good thing about those, and especially about the .law domain name, is that when you register it now, because it's been available for less than a year total, you know that no .law domain has any kind of negative history that can screw things up. And so we've launched a couple over the last few months that have been kind of rescue jobs on .law domains, and they've done really well. And so it's really just a matter of kind of figuring out where the line needs to be drawn, and then as an attorney making that decision that you're going to give it X amount of time to come back, and if it doesn't, then you've got to cut your losses and move on. And that's something that we counsel people on every day. And there's a more in-depth webinar that we've done on this topic in the past too, if you're interested in learning more.
So for attorneys who are unhappy with their current website company and they may want to change, what do they do? If they're ready to switch but they're worried about the time, the energy, the money that they're concerned that may have to go into switching, or they're worried about what could happen to their website in the interim, we've got a webinar coming up in a few weeks that will help you answer those questions. But Dan, I will let you get into depth on this topic.
Okay, and I won't beat it into the ground because I know we're going to do so very soon. But suffice it to say that we have these conversations nearly every day with attorneys that have websites on other platforms that are not performing well. And they're afraid, though, that if they switch, because the process is not clear to them, that if they switch, that there might be downtime, that they might lose ranking. We've seen customers who have gone from one of the major law firm website marketing companies, not gotten good results, gone to another and gotten even worse results because the site wasn't imported correctly. The inclination from a defensive perspective of website companies when you are not happy with them, and this usually happens when you're getting towards the end of your year or 2-year whatever contract where you're locked in and they need to get you locked back in for another X number of months or years, is to tell you that if you switch, you're going to lose all the hard work that we've put into it. We have never seen that be the case. We have never been able to find any objective evidence that any website provider has been able to provide any of our customers that validates that. In fact, we have the process of switching from every other website provider out there to Lawlytics down to a science. And there's just certain things that need to be taken into consideration to make sure that there is no downtime, that there is no loss of traffic, that there is no loss of momentum and so forth. And as long as those things are taken into consideration, the whole process should be so painless that the attorney shouldn't even notice that it's happening until the switch is made as far as the actual live website goes. And then we provide a system where the attorney can see the progress of their site as it appears on the internet, but in the safety of the Lawlytics sandbox so that they can kind of watch the progress. And then when we take over sites, the launch is simultaneous with the old site going offline. So there's no danger there. But the real question, I think, comes down to when you should switch, why you should switch, what you should be looking for if you are looking to make a switch, and when is the best time to start planning your exit from whatever company you happen to be with now to whatever company you are planning on going to. Yeah, and those are things we'll cover in detail on the 8th.
You know, Dan, I have a personal story I can convey about that. I started blogging, many years ago, and was on a blogging platform that was first introduced 15 years ago. And back then it was the latest, best thing. But then, over the years, the company that created this platform, it's called Six Apart, was sold. It was resold until finally 5 years ago, it was the remnants of the company were sold and to some business in Japan. It wasn't even an American company anymore. And I noticed that it was just becoming more and more clunky and difficult to use, and I was really looking for something new. And I'm happy to say that I found it at Lawlytics, which now hosts my blog. Just look up larrybodine.com and you'll find it. I got to say the switch from the old blogging platform to the new one was completely frictionless. There was no effort at all. And one of the things that I appreciated is whenever I log in to write a blog on Lawlytics, I always have the latest version. The software platform operates in the cloud, and all customers and members of Lawlytics also have the very latest version. And it's so easy to use. I just type a headline, I type the text, I insert a graphic, I can insert links. It's just all so intuitive for me, as an attorney. So for instance, the blog post I wrote last night about the New Jersey state bar notice, I composed that in about 10 minutes and put it online. This is after I had, not counting the time I'd spent researching the opinion, reading it, but when it came to actually writing it, it took 10 minutes and bingo, it was online. So, based on my own personal experience, I would strongly encourage people who are listening to this call to schedule an appointment with Lawlytics and just find out how easy it can be to update a blog.
Well, and thanks, Larry. And to that, I'd like to add, though, that regardless of whether you're considering Lawlytics or any other company, if you're not getting good results or you're getting good service or whatever is lacking with the current situation that you're in, don't be afraid to explore changing, whether it's to Lawlytics or whether it's something else that makes more sense to you. I think the Lawlytics will make sense to most lawyers because of the way that it's built and designed. But the thing is, I just don't like it when people are held captive either contractually with a web company or emotionally based on information that is not the truth. And the truth is that it is very easy to switch providers without any detriment at all.
So as it pertains to switching things around, we have another topic here that's sort of related, and that is what to do if you have multiple websites or blogs and when you should consolidate them. Are there reasons to have multiple law firm websites? Absolutely. And we did a webinar about niche websites about a month ago for those interested. And there are, of course, other reasons too, but as Dan might say, it's a decision that should not be based on emotion to have multiple websites. But what if you've got multiple sites and you realize it's time to consolidate? Let's talk about the reasons why you might have more than one in the first place and what the right reasons are to consolidate. And Dan, I'll start with you.
Well, so the reasons that we see a lot of people have multiple sites or blogs for the wrong reason is just the way that the market evolved. If you came online 10 years ago and you wanted a blog, it probably was likely to be on a separate domain or on a subdomain. There's no reason for that technically anymore. There's no advantage to having it that way in most cases. Then there were companies that took the more is better approach. And when you signed up with them, instead of selling you one website, they've sold you 5 or 10 or whatever. And oftentimes those websites did well simultaneously. And back then, not a bad strategy because you could rank for more than one site for particular searches, especially if the market wasn't crowded. That's no longer the case in most situations, although certainly we do have some examples of that still working in very strategic ways under limited circumstances. But if you find yourself in that situation just because of choices that you've made in the past, the internet's changed so rapidly that any strategy that you implemented 10 years ago is highly unlikely to be relevant today. The way that we like to look at it going forward is become intimately familiar with Google's guidelines. Those haven't changed substantively ever, really, in terms of what they're looking for. And so as long as you're following the core of those, you're going to be okay. But having multiple websites now is something that we oftentimes will take people that have 7 blogs on different topics with one company and 2 websites on different practice areas with another company and a blog or free blog somewhere like a Blogger or a WordPress free site somewhere. And help them consolidate it because it just helps to really concentrate the power of the message into one place rather than having it dispersed in an ineffective way everywhere. So that was the first part. Was there another question in the mix there, Tori?
Dan, go ahead.
Oh, no, go ahead, please.
All right. I can give an example of when it would make sense to have additional websites. I edit Mass Tort Nexus, which is a website that focuses on product liability cases against the makers of dangerous drugs and defective products. And typically in these cases, thousands and thousands of consumers have been harmed, but each one has been harmed in a very specific way, and this is given the rubric mass torts. And it makes perfect sense to have a mass torts website that focuses on talcum powder or the drug Xarelto or the drug Benicar, because in that situation, the attorney is seeking a very specific plaintiff with a specific injury from a very specific product. And a sole topic website makes perfect sense in a situation like that. However, I do know a plaintiff personal injury attorney who is marketing to all consumers in general. And this attorney had 10 different websites, and he was just scattering his efforts all over the internet, dividing his attention, and it was really not a practical approach at all. So what would you say, Dan, to an attorney who called you up and said, should I have my blog on the same site as my law firm or someplace different?
Usually on the same site would be the answer. However, we would really want to dive in and explore what the goals are, how much information is going to be posted on the blog, if it is separate, how often, that type of thing. Because there are good arguments for it, and we covered this in depth in some of our other recorded webinars. So if you're trying to figure this out, feel free to submit a consultation request, give us a call, or look at any of our on-demand webinars that deal with the topic. But it's not a cut and dry black and white choice one way or the other. There's a lot of nuance that goes into making the decision.
So our very last slide does have to do with the built-in blog and the potential benefits of having an integrated blog on your law firm website. Larry, do you have some experience in this area?
Well, I've always had a built-in blog. If you go to larrybodine.com, you'll find a general information site, and you can click on a link and you can see my blog, in which I, post news and commentary about current events. My interest is reaching as many people as possible by generating as much traffic to one specific destination. And I have to say it's worked exceedingly well for me in my own personal experience. Since I've had my blog online, according to the analytics, I've received more than 1 million visits over the last 10 years. So for me, it's an approach that's been extremely effective, and I continue to pursue it on my blog on Lawlytics.
So Dan, I know that there are some various pros and cons to the integrated blog on a law firm website. What do you think some of the pros are to having a blog that is built in rather than two separate sites, one for your law firm website and one for your law firm blog?
Well, I think it's a no-brainer that I think that every law firm website should have the ability for the attorney to blog, or the attorneys, I should say, to blog on their own website. The question of having a separate blog that maybe covers a different topic is a completely different issue. But if you're in 2016, if you're getting a website that doesn't have the ability to blog, you're getting technology that's more than a decade old, and you should always have the ability to be able to create blog posts if you want. Now, if you were going to look at it topically, so let's say you practice an area of let's say you practice family law, and most of your audience on your website are regular non-lawyers who are going through a divorce or have some other family law issue. And you're blogging, you're talking with them, about, well, here are things to consider about the children. Here's things to consider about property division, whatever, on the blog. Here's stuff that's going on in the news. That's great. But then let's say you also have this other audience that's mostly attorneys, guardian ad litems, other people that might be involved in the process from a professional capacity that either you just want to communicate with because it's part of what you do, or that might result in referrals. Well, having the information that is more directed to somebody with inside knowledge may, at times, depending on the volume and frequency of it, warrant having something separate because the audience is different. But in terms of communicating with that potential client, they're going to go to your website. They're going to get information about you. They want to know that you're open for business. It makes sense to have the blog communication on the same website as all of the other information, so that they have a continuity of experience and can contact you directly. It's just a matter of, do you want to segment off your audiences, and do you have enough to say to make that worthwhile to do it on a separate piece?
So that's all we've got for our topics today, but I know we've had some questions come in during this webinar. So I'm taking a look here. Dan, do you have any on your side?
Yeah, there are a few that have come in. And I'll just kind of take these from the bottom up. Is it best to create the page title or blog post title as the question? How can we ensure that we'll be found in the search engines? Okay, so I think this goes back to the questions around the long tail segment when we're answering specific questions that clients and potential clients might have. And really, you don't have to choose one or the other. For example, when you're creating it with Lawlytics, you type in the page title, you craft that page title really well, and that will also be the title of the blog post if it's posted as a blog post. If it's posted as a regular page, that will be the page title. It will also go into the URL, and everything automatically that needs to be done for the search engines to find it is done. Whether it comes up on an individual search conducted by a real human being really depends on how related that answer is to the question that's being asked. So the more precisely you can word the actual question part and put that in either as the title, if it's short enough to be part of a title, or as an almost immediate subtitle on the page, the better. But you're not going to be able to anticipate exactly how people are going to word things, because I could repeat myself over and over again and say the same thing in substance, but say it in slightly different words every time without even realizing it. So you just kind of have to paraphrase it as best as you can, taking into account what you think your potential clients might be asking, and then try to mimic the language to that. And then let's see, and Katie, if that if you want further clarification on that, let me know. Bunch of questions about specific things to do in New Jersey to make sure that it's ethics compliant. We really can't give specific advice, especially like there's a question about multi-state practices. So if somebody that's licensed in both New York and New Jersey, maybe they're a super lawyer. This doesn't say this exactly in here, but I want to make sure I'm articulating the question right. So you've got a super lawyers award in one state or the other, or in both states. One state might require the language to be one way, like New Jersey now has required, and the other state might not have come on record yet saying how they feel about it. My supposition, and Larry, please let me know what you think on this as well, is that if it were my practice, I would follow the most restrictive line and do whatever it takes to comply with the ethics in all of the states. And so if it means doing something that is maybe less in your face for New Jersey because you're licensed in New York and New Jersey. If it were my practice, I would comply with New Jersey all the way around. In fact, if I was licensed in Oklahoma right now and I saw this New Jersey thing, I would say, yeah, that makes sense. I'm going to do that too, even though Oklahoma hasn't given specific guidance on it, assuming that they haven't. But I would put it this way: if you find yourself sitting in front of a bar committee trying to and asked to explain why you did something or not, you don't want to have the answer be, well, I did it this way because although I was aware that New Jersey said this, I'm also licensed in New York. New York didn't say this, and so I did it this way. This is for New York. It's all kind of out there. It's obviously accessible to anybody, anywhere, if it's on the web. I would be extremely conservative with it.
Dan, the one thing I would add, drawing on my experience working at the Sidley law firm, the firm had offices across the United States, and it was the firm's practice to comply with the ethics rules in every state where they had an office. Now that meant, once we moved to Texas and Florida, we now had to pick up and reproduce online and in our marketing efforts the warnings that came from those states. You can't the firm was based in Chicago, and you can't take the position that, well, that's how are the disciplinary authorities in New Jersey going to reach me if I'm in Chicago? And the answer is they will reach your New Jersey office. As in all cases like this, I highly recommend you call a lawyer who practices in ethics law and get an opinion. This is what we're in practice to do. This is what our profession is all about. If you're not sure, call a lawyer.
Yeah, and I've, when I was practicing, when I was trying new marketing things, if I wasn't sure, I would just request an informal opinion from the bar. I know that can open up a can of worms, but I'd rather have that can of worms opened while I'm not in the line of fire than sticking my neck out there to see what happens. So I think that's great advice. So let's see. It looks like maybe another question came in. Hang on just a moment. So the question is, how do you think the First Amendment might apply to those that market themselves as top 100 trial lawyers or superb rating on Avvo? Sean, I'm sure you did a lot better in con law than I did. And so I'm not going to venture to answer that as far as the interplay. But Larry, do you have an opinion on that?
The First Amendment applies differently in different situations. If you're a professional and you're regulated by professional ethics rules, that applies specifically to what you are licensed to do, your First Amendment rights are going to be limited accordingly. I have seen cases where, attorneys will litigate their First Amendment rights extensively. And, if you're really not busy and you have time and money to do that, I encourage you to do that. I know of one attorney, I believe in Washington, D.C., that litigated for many years and finally prevailed. So it really depends on how you'd want to spend your time. Do you want to spend your time building your practice, getting more clients, generating more revenue, or do you want to spend all your time fighting with the state bar?
Yeah, and I don't know. For me, there seems to be a distinction between my right as an attorney to advertise and talk about my services in a truthful way, and my right to claim that I am something that resulted from an award, or that I have a reward if that reward connotes some kind of comparison with another attorney. So I kind of see it as a very gray area right now. Another question came in. Larry, I'll let you take this one. If your firm does not have an office in New Jersey, but attorneys admitted in New Jersey, do you suggest revising language to be in accordance with the New Jersey State Bar?
That's a very good question. I would have the attorneys admitted in New Jersey, pool their resources and contact an an ethics attorney in New Jersey and get an opinion. The point of our webinars is really to alert and notify attorneys of changing events such as this one. So I highly encourage you to tell all your colleagues about these webinars and invite them to log on and participate. All you need to do is just visit the Lawlytics website, navigate to webinars, and you can register. You will not get spam. You will get announcements about upcoming webinars, and you can mark your calendar. This webinar with Dan and me takes place on the fourth Tuesday of every month. So our next one is going to be on June 28th. You might want to mark that on your calendar and block out an hour at 10 a.m. Pacific and 1 p.m. Eastern. we love it. This is your opportunity to participate and ask questions. We will give you practical answers. It would be a fool's errand for us to give specific legal advice, because we know you wouldn't do that either. But this is where you're going to develop the questions and get guidance on which direction to look for answers.
Yeah, absolutely. Well said. So I don't see any other questions that have come in. This webinar has been recorded. We will have the slides and the recording available. We'll post it on our blog probably in the next couple days. And in the meantime, between now and next month, you're already if you're in this webinar today, you're already registered for next month's session. We have several other webinars that we're going to be doing over the next month. You can, if you go to lawlytics.com/webinars, you'll see a large variety of both upcoming live and then on-demand webinars that you can watch whenever you would like to. And with that, we'll go ahead and end. I want to thank everybody for coming. Thank you, Larry. Thank you, Tori. And hope to see you again next month.